The next topic that the Duke textbook takes up in the zoning chapter has to do with efforts to expand zoning beyond its kind of originally envisioned role to deal with other types of issues. And so the first one of those is the expansion of zoning to take in aesthetic concerns. And so we have a case that they're giving to us to illustrate that expansion. It's the case of State ex rel Stoyanov versus Berkeley from Missouri Supreme Court. The plaintiffs here are petitioning for a building permit so that they can build a single-family residence in a kind of an exclusive neighborhood in the city of Ladue, Missouri, which is, I guess, kind of a well-to-do neighborhood outside St. Louis. But the permit gets denied. It wasn't because they somehow failed to comply with the particular rules about how you build houses or what kinds of houses or what kinds of buildings can go in the particular area. They complied with all of the building and zoning regulations, they say, and all of the ordinances of the city of Ladue about building residences. The building permit gets denied because it was reviewed by the city's architectural board, and the architectural board decided to deny approval of the design. So the standards to be applied by the architectural board are set out on page 590. That buildings and structures within the city are supposed to conform to certain minimum architectural standards of appearance and conformity with surrounding structures. The unsightly, grotesque, and unsuitable structures detrimental to the stability of value and the welfare of surrounding property, structures, and residents, and to the general welfare and happiness of the community be avoided, and that appropriate standards of beauty and conformity be fostered and encouraged. And so here, the Architectural Review Board decides that the plaintiff's design does not meet those criteria because we are in a neighborhood that has certain kinds of houses and they want to build something very different. And so they give us some pictures of some of the kinds of houses in this neighborhood in Ladue. It's a place where you see lots of English Tudor and colonial and French provincial housing. But what the plaintiffs want to build is something modernistic. It is apparently pyramid shaped, has kind of doors and windows that are triangular in shape. So this is an artist's rendering of what it might have looked like if you had built this house in the neighborhood where they were wanting to build it, surrounded by its French provincial and English Tudor neighbors. And so the Architectural Review Board says we're not going to approve this design, and the case goes up to the Missouri Supreme Court. And the first argument made is that aesthetic regulation by an architectural board is not permitted by the state's zoning enabling statute. In other words, the state has delegated zoning authority to local governments, and this is not within the scope of that delegation of authority. The plaintiffs rely upon a prior Missouri case called McGidson versus Hinsey, where the court decided that the statute doesn't permit a city to impose aesthetic standards for buildings. If you think back to the Village of Euclid case, the primary concerns that were underlying the zoning process seemed to be concerns about health and safety. They were wanting to provide safe buildings with adequate fire protection. They wanted safe areas for children to play with minimal traffic. They wanted plenty of light and air. And so the argument is, well, when you're zoning for aesthetics, that's kind of going beyond what zoning is designed to accomplish. The Missouri Supreme Court decides, though, that the statute does permit aesthetic regulation. The statute permits consideration of, quote, the character of the district and its peculiar suitability for particular uses, and with a view to conserving the values of buildings and encouraging the most appropriate use of land throughout such municipality. And so the court concludes that aesthetic regulation like this fits within the statutory criteria, especially those having to do with preserving value of property. Apart from the statutory argument, the plaintiffs also make a constitutional argument that this is beyond the power of government because it's an unreasonable and arbitrary exercise of the police power. The court rejects that argument, that the aesthetic factor is not considered in isolation. It is an inherent factor that is considered in looking at the effect of the proposed residence on property values in the area. So the court, notes that this is an architectural board made up of people who are experts. But if you think about it, I wonder if you really need experts to decide issues like this. Does it really help to have experts involved? Does expertise play a role here? If the question were the effect of a particular design on property values in the neighborhood, well, maybe expertise would matter in that context, but maybe not architectural expertise. Maybe you should be calling real estate agents or brokers as experts to talk about the effect on property values. If the issue is aesthetic, though, should we really trust architects to have better aesthetic sensibilities than other people? Or should we just let aesthetic decisions, to the extent they're relevant, be made by citizens chosen randomly? On page 590, there is another issue that is raised by the plaintiff that is not addressed head on in the excerpts that we have here. The plaintiffs argue that the ordinance is unconstitutional on another ground because it is vague and provides no standard or uniform rule by which to guide the architectural board. And so why is vagueness potentially a constitutional issue? And that goes back to the due process clause that we looked at in the Village of Euclid case, that one of the things that the Supreme Court has said due process requires is notice. That you need to give people notice of what the law requires so that they can act in conformity with the law. A vague statute can be unconstitutional if it doesn't provide people adequate notice of what they have to do to comply with the law. And so if you look just at the statute or the ordinance that is quoted on page 590, does that really give notice of what it is that you cannot do? I mean, it kind of uses conclusory language: unsightly, grotesque, unsuitable. It talks about effects like detrimental to the stability of the value and welfare of surrounding property, but it doesn't really give you much clarity about what kinds of designs are permitted and should therefore be approved by the Architectural Review Board. So could you have an ordinance on aesthetics that was not impermissibly vague? You could have at least more clarity about what is permitted. You could certainly have pre-specified designs that are approved. You could say, if it looks like this, it's okay, or pictures or something. On the other hand, maybe there's an advantage to having a little bit of vagueness if you're going to engage in aesthetic regulation, because if you get too detailed about the guidance, then maybe you shut down creativity. So, one issue that you might think about is, do we really want to have the government kind of regulating aesthetic issues? Is it problematic to say that bureaucrats are going to be deciding what buildings are pretty enough to build? If you have a review process where a group of architects can turn down your building plan on aesthetic grounds, what consequences would you expect to flow from that? And one is that people might get might become unwilling to experiment with anything new because the planning process is costly and they don't want to kind of take a risk that their design is going to be turned down. And so maybe it would push people towards safe designs and make neighborhoods more boring. In the old version of the textbook, they have a quote from a famous architect named Robert Venturi, who doesn't like these architectural review boards. He says, quote, "Any artist could have told the lawmakers that you cannot legislate beauty, and that attempts to do so by the use of experts will result not only in gross injustice, but in an ugly deadness in the environment. Beauty escapes in the pursuit of safety, which promotes a simplistic sameness over a varied vitality. It withers under the edicts of today's aging architectural revolutionaries who man the review boards and who have achieved aesthetic certainty." So take a look at note 1 after the case that gets into the background and whether other jurisdictions permit aesthetic zoning. Remember that zoning was first approved by analogy to the law of nuisance, that it was a way of exercising the police power that was analogous to the police power exercised in nuisance doctrine. Well, in nuisance law, ugly uses of land are not deemed to be nuisances generally. If it's smelly, if it's noisy, then it may be a nuisance. But if it's just unsightly, they tell us that generally nuisance law does not condemn a particular property use. And in part because there wasn't a clear way to decide what is not beautiful enough to be permitted. And so if we were just going to continue with our analogy to nuisance law, perhaps we should say zoning law also should not try to regulate aesthetics. But the authors tell us that maybe a majority of jurisdictions now permit aesthetic regulation, and that was brought about in part by a Supreme Court decision, Berman versus Parker from the 1950s, where the District of Columbia was trying to tackle the problem of urban blight and was trying to kind of renovate a blighted area. And the court in that case approved the use of the police power by the District of Columbia. And so that decision has been influential and has affected what many jurisdictions now permit. So they tell us in note 2 that the holding, the court in Stoyanov didn't rest its decision on the legitimacy of aesthetics as a zoning objective. It instead talked about property values, but then they suggest that that really that's just kind of avoiding the main point because it is the aesthetic features that affects property values. So Frank Michelman calls that escapist reasoning. In any event, that is one of the ways that zoning law has expanded to cover new types of issues that were not the original purpose behind zoning back when it was being adopted in the early part of the 20th century.